Welcome, everyone. Okay, everybody can take your seats and we'll start with the next panel. I'll give you a few minutes to get seated. A few seconds to get seated. So, the title of this panel is The Pros and Cons of Professional Bankruptcy Directors. And I must give credit to the Wall Street Journal. I had a call from Alexander Gladstone, who was, I think, in the room, maybe he wasn't before. He wrote an article about this very subject and mentioned Professor Jared Elias, the author of it. And I said to myself, this is a very good idea for a panel at the Distressed Investors Conference. I think I'll call Peter Chapman and suggest it. So I did, and he said, good idea, but let's not repeat what's already been written. So with further ado, I'm going to introduce the members of the, actually ask the members of the panel to introduce themselves one by one, giving a few sentences as to their relevance to so-called professional bankruptcy directors. And we'll start at the beginning. Go ahead.
Hi everybody, my name is Lorenzo Marinuzzi from Morrison & Forster. I'm the co-chair of the bankruptcy group. A lot of my work is representing creditors committees, and often we find ourselves looking at transactions that were approved before bankruptcy filings by boards that included independent directors.
Good afternoon, everybody. My name is Harvey Tepner. I serve as, for the most part, an independent director on troubled companies both coming in, hopefully going Chapter 11. I've been doing this for about 6 years. My background is as an investment banker in troubled situations and private equity and alternative asset manager with W.L. Ross until I came into this new unexpected role.
I'm Howard Brownstein, president of Brownstein Corporation. We are a turnaround crisis management firm. I have served for many decades as an independent corporate board member, public companies, private companies, large nonprofits, and these have included distress situations.
I am Jared Elias, and I'm a professor of law at Harvard Law School. And I became interested in this topic, although since writing this article, I've had many people ask me, has it gotten you a board seat? And the answer is no. I've never been on the board of a Chapter 11 debtor or any other large company, but I have spent a lot of time reading and writing and thinking about it.
So I'm Judge Lisa Beckerman from the Southern District of New York, and before I was a judge, I was a partner at Aiken Gump Financial Restructuring Group, and I advise people in different roles, including public company debtors. A lot of hedge and private equity fund investors were my clients, and so I guess that's the relevance I have to this topic.
My name is Stephen Seiden. I'm president of Seiden Credo Associates, executive search consultants. I'm probably the only headhunter at the conference today, and we recruit directors and officers for companies entering and emerging from Chapter 11. So, while it says that I'm the moderator, I've told the panelists, and telling the audience, we want to turn this into more of a discussion than me firing questions one by one of the panelists. So I'm going to ask everybody on the panel to kind of be their own moderator and feeling free to ask questions of everybody else. And if the audience, rather than having a separate Q&A, if there's a particular question that you feel you want to ask a question of one of the panelists, please do. But without further ado, for those of you who haven't read Jared's article, I'm going to ask him to spend the next 5 minutes explaining what he means by so-called bankruptcy directors, how he came to write this now somewhat controversial but very topical and timely paper. And then after that, we're going to have a free-flowing discussion amongst the panelists about the paper. So Jared, I'm going to turn this over to you for a full explanation of exactly how you went about this and what conclusions you reached.
All right, so first, thank you to Stephen for suggesting this panel and for Peter to agreeing to it. So if you've been at this conference, which I was not, 15 years ago, you really wouldn't probably have heard all that much discussion about boards of directors in Chapter 11. And that's because traditionally or historically, up until relatively recently, it wasn't that much of a hot topic. There were 3 reasons for that. The first is that boards historically have not had experts in Chapter 11 or restructuring within their ranks when a company filed for bankruptcy. The second reason is that bankruptcy law, unlike corporate law, traditionally does not kind of valorize the independent director as a validator of the integrity of corporate decision making. Corporate law has developed a gigantic body of precedent that suggests, and there's also federal laws at this point too, Dodd-Frank, but corporate law is administered by the Delaware Chancery Court really relies on independent directors to make decisions. Bankruptcy law doesn't do that. Bankruptcy law has a truly independent person, an honorable bankruptcy judge who's appointed, not by anyone affiliated with the corporation. And then, of course, you have a creditors committee. And then the third reason is that boards lose their superpowers in bankruptcy. Where outside of bankruptcy, the board's superpowers is making extraordinary decisions. Inside bankruptcy, the board suggests actions for the judge's approval. So there's no real tradition of litigation ex post in bankruptcy that will lead to lots of attacks on the integrity of the board. Instead, something suggested to the judge, she finds facts and law, she approves it. It's like you're not going to then sue the board saying the judge was misinformed unless you have something truly egregious. But what I started to hear about a few years ago is that something important was changing in the way that companies were preparing for Chapter 11. And that something turned out to be that companies were increasingly, starting in about 2012, adding independent directors to their ranks, and these independent directors were people with true expertise in corporate restructuring and the bankruptcy process. So this was something I studied with a couple of co-authors, Kobe Castile and Ehud Kumar, who both at Tel Aviv University. And what we did is we went through all the large bankruptcy cases from 2004 to 2019, and we collected information about who was on the board. We also collected information on how do they represent the board to the courts and filings, especially in the disclosure statement. And what we saw is that there was this massive injection of expertise into the bankruptcy process, where, to give you some numbers, in 2004, 3.7% of large Chapter 11 debtors informed the bankruptcy courts that they had an independent director on the board that made the decisions that led to the plan. By the time we hit 2019, the end of the sample period, it was almost half, right? So that's a gigantic change in a very short period of time. So we looked at these directors, and what we found is that they have, 4 distinguishing characteristics. So the first, as I've already mentioned, is that the people who are put on these boards have deep experience in bankruptcy and restructuring. We found that 40% of these people who were held out as independent directors had been restructuring bankers in a past life. Disappointingly to me, as a former bankruptcy lawyer myself, only 19% had been bankruptcy lawyers, and another 16% had been distressed debt traders. Right? Others had operational or accounting backgrounds, but in general, this is a group that wasn't going to feel out of place in the bankruptcy court. The days where boards of directors relied on their attorneys to explain to them, what is this disclosure statement thing? Those are days in the past. The second thing we found is that when these independent directors were put on the board, they were often delegated to some extent. Different, varied from case to case. The board's decision-making power in Chapter 11, right? Either through a formal subcommittee arrangement, or maybe they worked as a leader on the board on certain topics. They were put into place at a subsidiary, or they worked under directors. There are different ways that this happened. A third thing is that these directors, clearly from how they were represented to the bankruptcy courts, were leaders in the company on bankruptcy matters, and they injected expertise into board deliberations. And then finally, it appeared to be the case that they were the lead negotiating counterparty, a lot of the time on behalf of the corporation, as they're negotiating with creditors, and as they offer themselves up as testifying witnesses. Right? Perhaps most importantly, the use of independent directors independent directors were being used to try to credential board decisions as deserving something like the deference that corporate law gives to decisions made by independent directors outside of bankruptcy. Outside of bankruptcy, judges avoid doing a rigorous review of the substance of a business decision. Instead, they ask, was this decision made by independent directors? Did they have a conflict? If the answer is no, that usually is the end of the inquiry. Right? And it's clear that there's a real effort underway to kind of graft this concept into bankruptcy law. And it's not necessarily contemplated by the bankruptcy code of judges looking to independent directors as almost deputies of the courts, quasi-trustees. to validate decisions and to provide the judge with greater comfort about something the company had done. One of the things that's complicated, and I'll stop in a second, is that I think the independent director title here is a little bit misleading. And the reason for that is outside of bankruptcy, we think of independent directors as being appointed by shareholders to represent the interests of shareholders and to not be sort of overly connected to management, to not have a conflict with respect to management. Inside bankruptcy, what I saw when I read court filings is that a lot of the time, independent directors, despite being appointed by shareholders, said we're almost like quasi-bankruptcy trustees. They were truly independent people, we're objective, we have no loyalty to anyone in the process. And all we want to do is accomplish all of the things that should be done to reorganize this asset efficiently. We just have the best interests of the corporation at heart. And we can talk more about conflicts of interest later, but I think that is a good overview of this, I think, tremendous change in the role of boards of directors in Chapter 11.
Excellent. Now, what I'd like to...
I made a friend.
You're going to ask one of the questions later. Okay, so what I'd like to do is ask all the panelists to state how they feel both pro and con about what Professor Elias has put forth. Let's start with you.
I'm supposed to disagree with everybody, so I think So, interesting observation about the facts. It's not surprising that as we got later in time, we saw more independent directors. And I don't know if that has to do with the complexity of the transactions leading to and occurring within the bankruptcy cases. But it's not a surprise to me to find that there's not really a lot to disagree with as far as the data. I think we can disagree, and we will, about how that role should be discharged, the obligations that the independent director has, and to whom. But I don't have any issue with the data, and I think that the research is well done.
Harvey, what's your take on Professor Elias?
Well, so he didn't address it here, but it's addressed in the article that he felt that companies had super directors, independent directors tend to have lower recoveries to creditors, which I disagree with. It may be true. I disagree with the conclusion based upon the data that he had. They focused mostly on unsecured creditors without much discussion about what industry they were in, what the cycle they were in, what secured creditor and second secured creditor recoveries were, what the EBITDA of the company was. And I think it's a reasonable proposition is that do independent directors or so-called super directors or so-called independent directors, are they there to do someone's bidding other than the highest return to the estate? Is that a fair summary of the hypothesis? I think the answer should be they should be there to get the highest returns and the best outcome for the estate. That should be the requirement right in. And I think it's a great question and a very fair question and worthy of discussion. I would suggest, and I've spoken to Professor Elias about this, that he should expand his study to try and take these other factors, which are hard to capture. If you're in the airline industry, everybody knows it's been cyclical until recently, or the steel industry or the car industry. And if you catch something at the wrong point of liquidity and the wrong point of the cycle, returns are probably less than if they have a bad balance sheet but a good part of the cycle. So I disagree with the conclusion based upon he hasn't done work, and I'll let him counter that if he wishes. As to the prior statement, the role of the independent director, however you point on, you have an obligation to both a good process and a good outcome, and they should ideally not conflict. The structure of bankruptcy becomes the ultimate event in trying to fix a balance sheet. And a lot of things are pre-negotiated up front with months, sometimes almost a year of negotiations amongst various creditor classes, especially with the advent of secured, second secured, third secured positions in structured debt, which makes it easier to do in advance and more complicated and expensive to do following Chapter 11. And an independent director can sort of help be the referee to make sure it's working well, it's working fair, they're not favoring one interest over another unfairly, and as well as trying to get a good outcome, which might be a sale, might be a reorganization, trying to raise some money.
Howard, what's your take, pro and con, on Professor Elias?
So two prefatory comments. First of all, I co-authored 2 articles on the subject in response to Professor Elias' paper. My co-author, Ken Rosen from Lois and Sandler's here. I'm going to acknowledge him. I also want to acknowledge the value of having empirical research on bankruptcy cases, because we have way too little of that. And so I applaud that, and I hope we have more of it. My opinion is that we all need the bankruptcy process to be squeaky clean. Those of us in the audience who are as old or as older than me can remember the Bankruptcy Act, and it wasn't very pretty. So we need disclosure, we need confidence from all parties in the propriety of the process. So to that extent, when anyone raises a concern, I want to listen. I want to find out if there's anything there. And I think there is something there. I depart from the professor's conclusion about what to do about it. I think there are things to do. We'll hear more about that later, but that's my take on it.
Judge Beckerman?
So, obviously, I agree with some of the things that Professor Elias wrote in his article, and I disagree with some of them. I find that the points that he made about the fact that maybe there needs to be more disclosure up front about directors and their relationships early on in a case is probably a very good idea. And that the disclosure maybe needs to be like the disclosure we have to have for professionals, which is pretty extensive. Some of that would be helpful because when the judge is looking at things and trying to figure out, does she or he really think that the transaction was properly advised, was it properly scrutinized, were there any, is there any concern about conflicts? It would be helpful to know that. But what I disagree with is the idea that the bankruptcy judge is going to end up now determining who should continue as the independent director, or whether someone should continue as the independent director for a corporation in normal circumstances. And part of that is because the role of the bankruptcy judge is very limited in the bankruptcy code. I mean, we have tools in 1107, we have tools in 1104, we have tools in 105. If you read the Delaware Code, you would think we could do anything under Section 303. I'll just say that. Basically, any order I enter is fine if it touches on anything in governance according to that section. But in practice, the case law, at least in this circuit, the Second Circuit, which is where most of the case law is on this, has been, in the bankruptcy process, has been that only under extremely, unusual abuse situations should the court be sticking its foot in of governance issues. And we obviously have abilities for people to move for trustees, people to move for examiners, things that are in the bankruptcy code. But otherwise, we're not supposed to just decide that now we're taking over all the governance and I'm going to replace, because I think it's a good idea, we'll just replace all the directors or half of them. That doesn't seem to me to be our role. And it would obviously put the bankrupt situation in something completely different than the way governance works outside of bankruptcy, where the shareholders control that process, because now the bankruptcy court would control that process in part, at least with respect to independent directors. And I do not look forward to being that person if I have to do that myself, but I think that would require changes in the law. I honestly don't think that absent some extraordinarily unusual circumstance, a bankruptcy judge is just going to decide every time a case is in front of them, they're now going to just exercise their discretion under the 3 words in section 1107 that might give you the ability to do that, and just thrust yourself into changing the board or saying that they have to get rid of like 3 of the independent directors. So that's where I disagree with Professor Elias.
Jared, how about a response to each of the panelists' pros and their cons, if you will?
So I will try to be brief as to avoid, can't respond to everything, but I'll respond to a few things that I think are important. One of them, to Harvey's comment about, do bankruptcy directors or independent directors drive lower creditor recoveries? So something that I see in the study is that if you look just at the cross-section of companies that file for bankruptcy and an independent director, and you look at those that don't, you just make 2 buckets. What you'll find is that unsecured creditor recoveries are lower in the cases with independent directors. Now, that's not to say that the independent director caused those low recoveries. I think what that teaches us is part of why this practice has become so controversial. So something that I was surprised to find, so I went into this research project alarmed by high-profile anecdotes like Neiman Marcus, where there was discussion about whether or not you get independent directors, whether they were doing? Were they doing their job properly? Where were their loyalties? And what I found is that only about half of the cases, going back to Lorenzo's comment, do you find independent directors who pre-bankruptcy investigated some sort of insider transaction. Actually, like, these independent directors are being put on boards in cases that don't involve any kind of allegation of private equity self-dealing or liability management. The trend is bigger than just, did you do a leverage recap pre-bankruptcy? Should you have done that? Like, this is bigger, and it kind of goes to where a professionalized Chapter 11 is headed. Where once upon a time, like if you filed for bankruptcy, you didn't do a keep or a curb at the beginning of the bankruptcy case. Then you reached a point when like nearly everybody did, because that was just good hygiene. And it feels like this is evolving into a much larger practice and a change in boards that is bigger than just, let's see what happened. But I certainly don't think that these independent directors are causing these worst cases. It's just that you have these more challenging situations, and those companies seem to be looking, at least at this point in history, this is 2004 to 2019, looking to beef up the board expertise, perhaps because they contemplate litigation, or viewed uncharitably, perhaps because they want to try to cover things up, although that's clearly not the majority of cases. And this is a really big trend. And also respond to Judge Beckerman's point. So in the article, I suggest that, well, maybe you should have more disclosure. So at the beginning of the bankruptcy case, you want to have some independent director whose biography you rely on and inject as part of the analysis. Because, like, here's the difference. So I can have, Harvey Tapner make a decision, and prior to 2012, like, I wouldn't bring Harvey and his long biography of having been on lots of boards and done amazing things with Wilbur Ross and all this other stuff. I wouldn't bring that to the judge's attention. Like, I just brought the decision to the judge's attention. The judge decided, did this decision comply with the bankruptcy code? That's changed, right? And now, the judge is informed not only of the decision, but also of who made it. And so the point I made is, well, maybe we should go back to a world where you don't talk about who made the decision unless you do some extra work to try to credential, essentially, an expert. You say, if I want to put Harvey Tapner's, long resume forward and staple it to this dip motion, like, let me tell you about him, and then let me tell you about all his conflicts. And then let's see if the parties to the case agree that he's truly independent. If not, let's just take the resume off him. I do agree that, I'm asking judges to take, sort of leaps with their equitable powers, which, may be super expansive, may not be, depends on the circuit, depends on the judge, in order to try to deal with something that I suspect Congress will never touch. But there's a lot of precedent in kind of bankruptcy history for innovation being brought into the system, such as let's sell the firm through Section 363, and then judges create common law guardrails, like the Second Circuit one, Lionel and other cases, that help us understand, well, so lawyers have come up with a new idea.
That's
where does
based
this
on
go?
a statute that was passed by Congress. This is my deciding that I'm now going to move into a territory that Congress really didn't address in the bankruptcy code, and for real reasons.
Let me say something about the background here for a minute. So the bankruptcy code and rules do not constitute all the laws and regulations to which a debtor is subject. The debtor is a corporation organized under applicable state law, and there are many other compliance regulatory schemes to which the company is subject. Securities regulation, exchange regulation, who knows? The point is that there can be plenty of ways in which a company may be not following the rules that have nothing to do specifically with the bankruptcy code. And the parties in the case already have standing to bring an objection to the court about such non-compliance, and that would include failure of corporate governance. There would be no directors if you didn't have a state corporation law. So I think that we already have the table somewhat set, but what is missing, from my viewpoint, that might be an enhancement would be a mechanism for disclosure that would go beyond what 327 already requires for professionals. So if the debtor's counsel has appointed this director 12 times in other cases, I would think that would be a connection that would have to be disclosed in the affidavit under that lawyer's application for employment. On the other hand, if there is no professional in the case with such a relationship, then that is not going to get disclosed as of now. And maybe that would be an enhancement we're looking at. What I object to is shifting the power to the creditors to now be involved in the inner workings of the debtor, its corporate governance, and whatever else. Because I don't think that's appropriate, just my opinion.
But isn't that what often happens with creditors? Because it's usually creditors that are looking at transactions after they happen and evaluating what the independent directors did and whether they were in fact independent. And that's how that relationship or those relationships and any alleged conflict or less than perfect conduct in approving transactions comes to light. So in some respects, it is the creditors that are actually the ones to kick the tires and check to see whether the relationships between the independent director and whoever put him or her in place are okay.
And I agree, they have standing to object. What I don't want to do is give them the power to approve when there's no problem necessarily. That would be a shift in control.
And one of the changing landscapes of the creditor investigation, which is right, proper, and bona fide, is sometimes a fishing expedition. Sometimes it's a really terrible case in terms of potential recoveries, and it's often never hold-up value. A couple of times I've been engaged specifically to be an independent to review prior transactions with an independent counsel to see if there was noise in the system, to see if there was colorable claims, and decide if there was or wasn't. Not to take away the role of the creditors, but to sort of supercharge it, let them look at everything we did. Let them look at everything we did, re-interview people if they wish, join interview with people if they wish, just follow our trail, but to make it a little bit more efficient. So there is some utility, a very special purpose independent director role for that, things you can start ahead of the Chapter 11 filing to begin the process, so you're not stuck just doing an investigation and slow down a little bit, those will be quicker exit.
Well, sometimes I think what happens, Harvey, is that it's necessary to do that pre-bankruptcy because there has to be some type of resolution in connection with the restructuring on something, and that can't wait. And maybe the RSA or the plan that goes in, someone has just a plan that they're going to propose on day one or solicit before, has to have some sort of investigation that has occurred at that point to figure out what's going to happen with that under that circumstance. And so sometimes that truly does have to happen before the bankruptcy occurs, and it's not because people would otherwise not want to put it off, but it's because in order to get to a deal, it's not possible to put it off.
That's right, and also most of these companies are not exactly rolling in lots of excess cash.
Well, and the judge used the word wait, and I want to focus on that because unless the debtor is making good red Zinfandel wine, time is not your friend. It's not going to get better if there's more delay. It's going to get worse. So anything that's going to slow things down unnecessarily, I think, is a risk. And I think it would be better to build in some disclosure requirements and call it a day. And then if anybody has reason to object, they already have that power to do so. And if that's what they want to do, and they think that will improve their position, that's their right.
Well, I also think that it would be helpful, the disclosure aspect that Professor Elias suggested would be helpful in other ways, as pointed out by the judge, because we're called upon sometimes just during a case to render decisions on transactions, and we have to look at people's reasonable business judgment. And I know one of the things that we had talked about before in preparation for this panel was, what happens when, you have a concern about whether the parties that were making that decision had some sort of, role in it. And that could be as limited as management wanting to have someone ends up owning the company because they have a role going forward and they have some sort of compensation. It could be that the directors have other roles and how things got negotiated. It could be that you have a loan-to-own transaction and how that works out, for parties who were in another position as well in the capital structure and in the boardroom. And so when a judge is trying to evaluate those things, it really makes sense to try to have that information available to be helpful, because we have to decide, is this just a reasonable business judgment standard, or are we talking about heightened scrutiny? And we don't know about the relationships. It's hard for us to make the right call. We're always going to go with reasonable business judgment because we don't know that it requires something more. Sometimes we have a sense of it, and we'll look at it under different standards, but it would be helpful so people would understand that. Or should we view the board of directors having approved this transaction as a really good thing? It was very independent, people seem independent, they went through the right process. Is that helpful in our reasonable business judgment? Or is it not? Because that's not what happened. So I think those would all be things that could be helpful along the way. That's why I think the disclosure idea is probably a good one.
Your Honor, a lot of evolution in disclosure rules and just general bankruptcy practice happens when judges start asking questions. So I would imagine.
Are you talking about me since I asked a lot of questions? I'm notoriously known as a Budinsky judge.
I would, which is fantastic, but if more judges would ask the questions, like for example, you have a DIP that's presented on day one, and the first day declaration and the DIP motion, the declaration supporting the DIP motion will say things like, the company evaluated 2 different sources of DIP financing, and then you have another party that was shunned as the DIP financing party who objects, but nobody else really has an opportunity to weigh in on it. It would be very helpful if the company were to rely on the independent director evaluating the 2 possible DIP transactions and choosing A over B for courts to ask questions about the independent director of the process and when they were put in place and how much time do they have and who do they hire, do they independently investigate it with their own analysts or did they rely on the company's advisors, etc. A lot of those questions get answered too late in the case for issues like the DIP, for example, where it's already baked in with an interim order, there's not much that people can do. So if courts, like Your Honor, would ask the questions of the debtors when they were presenting these motions for relief, then I think that would go a long way to creating a practice within the bankruptcy courts where these connections, these relationships, this experience got out there on day one as opposed to eventually as part of a contested process 6 months into the case.
One of the things that I think is interesting is that the board conflict here is somewhat novel. If you look at the potential conflict of interest of independent directors, if you look at corporate law, there's a gigantic body of cases that deals with the question of, well, what if this director is also on the board of the same university that the defendant went to? And a lot of what if this director was sorority sisters in college with the CEO? Like, when is that person an independent director? There are a lot of cases on the topic. But the conflict here looks a little bit different, and it's kind of unique to the setting of bankruptcy. So one of the things that we found in our research was that you rarely, if ever, saw the same sponsor and the same director working together again. Now, I say that with qualifications because we don't observe stuff that are going to court, and we don't always know who the sponsor is. Sometimes that's information that's hard to glean from the court docket. But you don't see Apollo working with the same director over and over. So the conflict here would look something like, well, if I'm put on the board by Apollo, I'm going to do a good job. I'm going to do a job that makes Apollo happy. Not because Apollo's going to hire me again, because they won't. Because in all the documents and conflicts that makes it too easy to disqualify me. But rather because I've shown that I'm a good person within the broader world of people who get on the board of private equity sponsored companies and do Chapter 11 things that are in the interest of the sponsor, whether that's a cheap settlement of an asset that was conveyed to the sponsor or something like that. And so it's a very challenging conflict to potentially police. We call it an audition bias, where you worry that maybe you don't have the best interests of the company at heart. You're really looking out for yourself. I don't know for a fact that this ever guides anybody's decision, but that's the kind of moral hazard problem that you would identify in this setting, where you don't see the CEO is like best friends with the director. The people who choose who to put on the board do a better job than that. So they're not putting on somebody who is obviously tainted with 150 engagements for the same sponsor. And so I don't know what you do with that necessarily as a matter of law, other than to say that there's this sort of repeat play dynamic that is challenging, and it's challenging to deal with, and it's not something that Delaware corporate law has a lot of advice on.
So, in terms of whether someone is put on the board by a sponsor over and over and over again, it's usually because that person has got good skill sets, but probably would not qualify necessarily as an independent director. Apollo put me on 10 boards. I don't think I would be that independent. But Apollo put me on one. I think I'd probably stand a good chance of still being independent. I am still waiting for that one. They haven't returned the call. I think sort of going back to the bigger question, why do you need an independent director? Well, good corporate governance generally has independent directors for public companies. There's all sorts of standards, well established, not what sorority you might have been in, your wife might have been in, or whoever, but family ties, and having filled out several of those forms. It wasn't quite the proctological examination, but it most certainly got into the weeds. If as an independent director in these situations, you should bring really two things. One, you should really bring real independence. Two, you should bring some knowledge of the process so you don't get bamboozled by your advisors, which usually good advisors, that will never happen. And you don't get railroaded by someone trying to do a sweetheart deal, especially if they're an insider. And it's very important. Second is you should have a clue about how to be a good CEO advisor in a way, sort of both process-wise and general business-wise. And those are probably two really important elements that you don't see people focus so much on process. We have a transaction, let's get it done. And the earlier you find an outside independent, 6 months, a year, whatever it is, if you know there's going to be a problem, to specifically address some form of future restructure, probably the better off the situation is. And I actually want to ask Lorenzo a question, which is, you've done a lot of committee investigations. What was the most sort of egregious thing that you see repeated? This I need a playbook for self-defense.
I'm happy to give you a step-by-step on what not to do. So one of the things, and I'm not going to point to a particular case because we've been looked at a lot of independent directors in a lot of cases. And there's two different things you focus on, the people and the process. So the people are kind of less problematic because, as you mentioned, there isn't a lot of directors that are always involved in a case with the same equity sponsor. What we've been finding is more problematic is the process. And by process, I mean, what was the timing of the appointment of the independent director? How much time did they have to evaluate the transaction that was basically transformative for the company leading into a bankruptcy case? What advice were they given and by whom? And what questions did they ask? And what did they look at themselves? So what you want to see in an independent director is somebody who actually takes the time to read the documents. Somebody who actually understands what the documents say, who understands a little bit about the business and restructuring. Somebody who's advised by someone other than the company's advisors. You want to see that level of independence in an independent director. It's a little bit more expensive, yes, but somebody who's able to say, well, I don't agree that this case says this necessarily, or I don't agree that the projections necessarily indicate this. And so when you see all of that done, you look at the process and you say, okay, this independent director truly was acting independently. It's the situation where a stack of documents are handed to an independent director during a deposition. It's the first time that independent director has ever seen the documents. That raises red flags about the process and what they looked at and what they thought. And we've seen in a couple of cases where judges have come down against the work of independent directors and CROs, that they expect these people to be informed, to actually take the time to educate themselves, to learn about transactions, to understand the implications of them. And so you want to see when you're investigating a transaction that in fact that was what happened. Not that somebody just accepted and rubber stamped documents that were put in front of him or her by other members of the board. You want to see that when they made these decisions, they were truly acting independently. They didn't have a room full of people telling them they needed to do this. So you really want to understand the process. Person is less problematic than the process when we evaluate these transactions.
So one question to think about for the future is, were we to decide, yes, some additional disclosure around the corporate governance of the debtor wouldn't hurt. And we don't have to make it into something that will automatically cause a lot of delay. But if what is disclosed causes concern, then there may be delay if parties raise questions. Right now, to my knowledge, in the bankruptcy code, that does not exist. We have 327 for professionals. The question has been raised, well, do we want to use the same standard, i.e. that of quote-unquote connections for directors? Are we going to make this retrospective, maybe a year leading up to filing date, almost like a preference period for insider transactions? What exactly do we want to have disclosed? I will tell you, without such regulations, if I'm involved in a case, I'm already going to disclose that because I don't want delay. I'd rather put it out there to all parties. By the way, I've worked with this attorney 5 other times. Here are the cases, here are the docket numbers, blah, blah, blah. I'm not required to do that, but I would do it because I just don't want any problems. It's like dealing with UST. You want to stay way out in front of UST. You don't want them doing anything because whatever they do is going to be bad for everyone, including them. But they got to do it. So you stay way out in front of them. Any bad news they hear from you. Similarly, you go into a case and there's anything that might even raise an eyebrow, you disclose. But that would be voluntary under the current rules. Should we have a rule, a code section, whatever, that requires that? Should we do it on the local court level, or should we amend the code?
Well, I know Professor Elias thinks we should definitely do it in our local rules. Because that's what he told me before. I think honestly this would have to be something that would be adopted, appropriately as some sort of disclosure requirement, because I think otherwise you have some of the issues that we see now that come up in, some courts requiring this, some courts not requiring it. The type of disclosure that's required would be different. Who's going to police the disclosure? That's going to be an issue, at least with, with professionals. There is the U.S. Trustee's Office, if people fail to disclose properly relationships, there's somebody whose job it is to, in addition to other parties, to raise issues. So there are issues to be raised. So I think that would be an issue. I don't think it would be something that you would just see in a local rule myself. It could be. I mean, you're right that it could be. We require all kinds of things. But usually we require all kinds of things based on something that's in the statute. And this is not in the statute.
So a question that I have for the group is, one of the major roles historically of the creditors committee is to get in, get appointed, get familiar with the debtor, and to do an investigation of everything that happened pre-bankruptcy post fishy. So how do we evaluate this new world that we're moving into, where maybe the good version of this is you're handed all the materials of the independent director and told, well, look at all the work they did, like go read all of this stuff, read the deposition transcripts, and you can go re-interview whoever you want, but the work is mostly done. It's like maybe that's the good version of it. The less good version of it is something more like you've seen in some other cases where you end up with a competing investigation with the creditors committee over here, the independent director over here. The independent director is the one who has the power to propose a settlement to the bankruptcy court, not really the creditors committee. Any litigation claim is an asset of the corporation. So what is the role of the creditors committee in this new world? And how do we police when a board oversteps into territory that the code rightfully reserves for creditors committees?
So I think it depends on the timing of the investigation and what was investigated. So for example, in many cases, there is a settlement between a company and, let's say, a sponsor, where the sponsor is agreeing to put in a DIP, they're going to get releases, and an independent director evaluated. When you're appointed as a creditor committee counsel, you obviously have an obligation to challenge that release. You have an obligation to understand the nature of the claims and what was done to investigate it. So ideally, you start with talking to the company about talking to the independent director and seeing what the independent director evaluated. The problem is most of that discussion leads to, we can't show you because it's privileged. And so then you start asking questions about who conducted the analysis. Well, it was debtors counsel that helped me as the independent director. Well, that's not exactly the investigation that you'd like. It's independent counsel. Okay, that's fine. Let's have a conversation. I think you have an obligation as a committee to conduct an investigation. The question is, how far and deep do you go with the background of an investigation already having been conducted? At some point, you will wind up in front of Judge Beckerman because you will seek discovery. Somebody will say, we've already looked at this, Your Honor. This is an unnecessary, expensive fishing expedition. Please don't require us to produce our internal emails on this. And Judge Beckerman is going to hear what the company and the independent director have to say and decide whether it's enough. If it's let's say a release under a plan. So plans, as you know, can provide for releases by the debtors of claims they have, estate claims against third parties. And very often we find we've investigated conduct of the board and found that they did things, not the independent board necessarily, but the board, and we find things that we think warrant further investigation, we believe claims exist, and the company will tell us, well, our plan releases all those claims because we don't think they're good. And you'll ask the question about, well, what did you do? When did you look at it? And they'll say, well, we asked the independent director to look at them last week. So you file the claim 10 days after you ask the independent director. Doesn't sound like much of an investigation. I'm being a little dramatic. But when you look at the facts as they're presented to you for an investigation that you're supposed to rely on the independent director to have done, some of them jump out at you as being just incomplete, and then you have an obligation as county counsel to investigate. And again, if the company or the independent director thinks you're overstepping your bounds, you go on in front of Judge Beckerman, and Judge Beckerman will have to call balls and strikes.
The advantage is you have a judge to determine these things. May not be what people want, may actually cause delay, but you have a judge, and that's an important part of jurisprudence here. For me, I always wanted this to happen 2 weeks, just in case people wanted to know. Not just 10 days. It's got one laugh out of the audience. But you really have to have independent directors who actually have good judgment. And you can't, if you're an independent director, you work with the board for a year, and it comes to the very end, and they want to give releases for A, B, and C, you haven't had a chance to affirm that, then it's very fair for you not to render judgment on that, let a creditor committee investigate that, because you can't be rushed with something you haven't thought of, and you hadn't been able, in that case, maybe you need to have an independent counsel for that specific area.
And Harvey, you raised the time for 2 weeks. I knew you were kidding. But
I was kidding.
what we often find, and this is, I also sometimes represent boards and companies, believe it or not, what we often find, and I'm sure I'm not alone, is companies that are struggling are very resistant to acknowledge what is happening. Very resistant to bringing in outside help, consultants, CROs, people that can actually help them operationally, and also legally, to bring in people who are independent and bring in counsel to evaluate the process. And so when you're on the company side, or if you're an equity sponsor and you have a troubled situation, you really want to think about, what if I'm wrong? What if this money is going to run out? What if we can't stretch our payables like I propose? You want as much time as possible for independent directors to come in there and evaluate the situation, so when you give the independent director a decision to make about dip A or dip B, or favor this creditor over this creditor, that they were there long enough, and not just 2 weeks, to say, okay, I evaluated the situation, and now I'm in a position to make a decision. So the timing is incredibly important when you're looking at this 2029 cycle.
Howard and Harvey have both served on pre and post chapter 11 boards. What's your prescription? First Howard and then Harvey. What's your prescription for an ideal board? And based on your own experience, what are your most successful and least successful experiences on pre and post bankruptcy boards, and how what Jared has just put forth might you have done differently?
Well, so in my case, I would say that, what you want to do is avoid anything that's going to cause delays. You want to overdo the disclosure, overdo the reach out, overdo the connecting to all parties, including creditors. Make sure that you can instill as much confidence in them as possible in the process you're following, so that you won't get unnecessary objections. If you're in a situation where it's too late and there's already a controversy, or you enter the situation after the controversy has begun, try to get the parties together and show them the potential cost of too much delay. I've had mixed results in trying to do that. It really depends on who's involved and what the history is. In cases where there was dishonesty on the part of the debtor, and so maybe there's a CRO or a Chapter 11 trustee, it hasn't been very successful. Nobody trusts anybody. But most of the time, in our world, we all know each other. That's how we get things done. You can reach out to the people involved, the law firm, the bank, etc., and try to get people on the same page. And you do that by sharing information. And you make sure they get the information from you before they get it from anybody else. Harvey, what do you think?
There's a lot to unpack in all this. In post-bankruptcy, the ideal board has all the confluence you want. Someone who understands the industry, someone who might be good in capital markets, Some of them may be good in mergers and acquisitions, but clearly you need a mix. Not to have too big a board and not to have too small a board. In pre-Chapter 11 filings, you'd like to have all of that. You also want someone who understands the process. You also need, the most important thing is what's the quality of management and the information that they're giving you. What's the relationship between the funding creditors of the company as opposed to the trade creditors? Because usually you want to keep the trade creditors at bay as much as possible, but they always tend to notice when you stretch your payables. And good information and good dialogue with the board and leadership on the board. Someone who knows how to go from point A to point B. Someone who would stand up to the CEO when the CEO is making a poorly informed or poorly fashioned judgment. It gets more complicated if you're not comfortable with the competence of the CEO. It gets exceptionally complicated if you have a CEO who we think is dishonest. And I think all of us in various forms have seen all those plays. I'm not sure there's any particular ideal board, but you do want to have, as your independents, honest, thoughtful, engaged people who like to stay awake, not only at board meetings, but beyond that.
So I asked the question of the panel, would a practical solution to this whole bankruptcy director issue be to populate the board for a company that is troubled with a mixture of both bankruptcy directors, those who understand how to take in and out of bankruptcy efficiently, and then going back to what Harvey just said, maybe you need to also populate the same board with people who satisfy committee eligibility, particularly audit committee, where Starbucks is very explicit on the kind of expert you need, as well as people who understand the guts of the company and its strategy going forward. What we do when we try to recruit one of these boards is we create a matrix, which we talked about earlier. Across the top, all the potential candidates for the position, and down the side, their eligibility, both committee eligibility, maybe it's common benefits, maybe it's management, maybe it's manufacturing, what have you, and then the various other committees and how they operate. Or, that's number one, a board that will last through the bankruptcy, or is your prescription maybe to reconstitute, knowing that you're going to reconstitute the board after the company comes out? Which is the ideal solution?
I guess I'll jump in. From practice, I mean, my experience was reconstituting the board on the way out is something that generally is going to happen. It's going to happen because usually something happened with the capital structure that changed, maybe who's going to end up owning the equity or in control of the company. It changed because now you're going to be focused on a restructured company. Sometimes that means that the company shed certain types of businesses. Sometimes the company is going to be focused on certain types of businesses, and you need to have a board that's going to be a good choice for that, in addition to the things that Harvey mentioned are ideal for a post-emergence board. This is especially true if it's a public company that's necessary. Private company, you're probably going to have a lot of it geared to the capital structure, but the board may just be completely different coming out for that reason too. So I think you're always going to see a lot of changes at the end, myself, long term. Going into a proceeding, I think a lot of the work we've been talking about that has to happen before a bankruptcy filing, including investigations, maybe transactions are going to have to happen, all the negotiations and the restructuring. Certainly would say that it would be helpful to have people who have that expertise and understand the process on the board heading in. So I think ideally you might have different skill sets that were necessary to get a company in a bankruptcy and into the proceeding and understanding the proceeding and what it's going to look like when it comes out. Some of that you might know when you go in if everything is organized and negotiated out before the filing happens, and sometimes you may have no idea because it's just that you didn't have that sort of organized process.
We have a few minutes remaining. Any questions from the floor? There was one here before, perhaps not.
Judge, I want to commend you for being so conservative in your
Microphone, please, gentlemen.
I'd like to compliment the judge for being so conservative in her subject matter jurisdiction. And press you for being so liberal, and like it's a cool little. I'd like to talk about the conflicts between both your positions as to how far the judge should go right up front, regardless of what's happening with the disclosure. That'd be nice, perhaps.
Can I turn something up, sort of a related question for you? Which
Sure.
is, so you're a judge. You've been a judge for a little while. Before that, you were a baker, so you were much longer.
32 years.
What do you expect from a board as a judge who's sort of really needs the debtor to do a good job in order for this money to be saved or turned around or whatever else is going to happen? What do you expect from a board, and do you think those expectations have changed over the course of your time in this profession?
Well, maybe the board has changed somewhat in the time of my profession, because now we're talking about decades. But I think, prior to Trenwick and Giwala, you might have had a different perspective as to when, what people looked at and how cautious they were when there was any argument of zone insolvency. So I'm sure that does, and I think I can say it from practice, that it can impact how things are. I don't think personally myself that impacted that much about the way I advise boards when I was in practice, even after those cases, because I think the cautious thing is to think about those things anyway, because you are going to have to, if things don't work out, you're going to be in an insolvency situation for sure, and those things are going to matter. So I think those, even though there's no rule that other stakeholders should be considered in decision making, I think the better way is that people would think about that in practice when they're advising people. So I definitely would say that. In terms of how I look at what I expect from the board as a judge, I mean, it's really more how's the corporation making its decisions? Are there things that are, I guess, controversial or difficult? What was the process that was being used for that? I mean, I'm not shy about asking people questions. So I have asked people questions about their process. But usually when it's the beginning of a case and people are asking me to do something fairly extraordinary. And remember, from my perspective, I was in practice for a long time. If I haven't seen it, and it seems very on the upper end of insane and what's market to me, you are going beyond the level where a lot of other judges would even consider it, because I think I'm fairly commercial in my background. And so if I see that, I'm going to hone in and ask a lot of questions because of the board, of the advisors. There's one time I had a hearing where I spent a first day hearing where I had 4.5 hours on a different out of it. And it was because I couldn't get a good answer to my questions. And I couldn't, and finally, eventually it happened, but I had to ask a lot of questions. And that was a very experienced firm and very experienced financial advisor, and clearly people just weren't prepped right for it or hadn't really thought about how on the upper end of what they were doing in terms of I guess, comparables they were asking me to do on something. And I do my own research, that probably scares people too. So when I see something that's really bizarre, we'll look into it and we'll see if we can find where anybody's ever approved something like this, because I'm being asked to make decisions that are difficult. And if I felt that the board wasn't, and the process had to be right, I certainly would ask about that too and feel uncomfortable about it. I know at the end of that hearing, I had to make a decision that didn't make me very happy, but it was necessary. And I had to decide whether I was balancing a small group of people who might be adversely impacted by it versus all the other parties, including all the trade creditors and all the unsecured creditors, and who would be helped by it. So I had to make a tough decision, and that's sort of those things. So I would ask questions about what the board did and what was thought. I mean, it's not just a rubber stamp. I can say that for sure in our district. I know Judge Bentley would agree with this. That when we have a dip that's put before us, especially with or anything in the first day that has very complicated or things that are going to dictate things, it's not something that we take lightly, and we all, I think, spend a lot of time trying to figure out ways to do no harm is our rule as much as we can, because we know the creditors committee needs to have their chance to do things. And
Thank you.
so we have to push back a lot of times on things that we, you know, legitimately have issues with. And like I said, if I have an issue with it, just saying, there's a reason for it. So, because, you know, I think that's just true. So if you get into a situation like that with me, you're gonna know that, that I am pushing back. And I'm not shy about asking questions. So I guess that hopefully answers your question about what at least I would do.
I think we're kind of out of time, so I want to thank all the panelists, particularly Jared Elias for having written the paper in the first place, and to Alex Gladstone of the Wall Street Journal for writing the article that gave you the idea to assemble all these experts. And so huge thank you to you. And one thing that I also want to do is to thank Peter Chapman and Will Etchison of the Beard Group. They, year after year, put on a tremendous conference, and I'm sure that a lot of work goes on behind the scenes that we don't know about, because this is one of the best, so thanks.